We are live now.
Thank you and good morning to council. This is a special session of the Kansas Court of Appeals, continued from our Wichita docket last week, meeting by Zoom today. My name is Catherine Gardner and I will serve as the presiding judge today, so I'll be keeping time for us. And I'm happy to be sitting with Judge Lori Bolton Fleming, who joined our court a few months ago, and before that was for 13 years a judge and then the chief judge in the 11th District Court for Kansas. So welcome to her. And you'll notice that our third judge on our panel today, Judge Coble, is not with us. She had an emergency this morning, but please be assured that she has read your briefs and she will watch the recording of this oral argument later and will deliberate with us before we decide this case. So she will still fully participate in the case. So with that, I will go ahead and call our case set on the docket today, which is 128006, David Greene Jr. and others versus the Kansas Department of Revenue and Steve Stotts. So counsel, may I have your appearances, please, for the appellant?
Thank you, Your Honor. Appellants David Greene Jr., Marcia Greene, and David Greene III appeared through counsel Braxton Morale of Dubuque, Gillen, Rathbun, and McIntyre.
Thank you.
And office with me.
Thank you. And for appellees?
Adam King appears on behalf of the Department of Revenue and Mr. Stotts.
Very good. Counsel, appellant may begin, and please let me know if you'd like any rebuttal time.
Thank you, Your Honor. Can I reserve 3 minutes for rebuttal?
Yes, you may. Please proceed.
May it please the court. I want to give you all a quick background on a rather lengthy series of events. After this background, I'll go through the district court's sua sponte dismissal of the appellant's Fifth Amendment 1983 claim, and then I'll move on to the appellant's claim under tort. Plaintiffs are David Greene, Marcia Greene, and David Greene III. I'll refer to David Greene III as Davey from here on out. 13 years ago, the Kansas Department of Revenue levied a $460,000 tax assessment against David Greene and Marcia Greene for a potpourri substance known as Diablo. The Kansas Board of Pharmacy had held an emergency meeting, and they deemed Diablo, and more specifically, chemical components of Diablo, UR-144 and FUR-144, to be controlled substances. As a result, the assessment was made. Now, the assessment should have gone away in September of 2014, when the Kansas Board of Tax Appeals held that any tax assessment on those two chemicals that was imposed before July 1st, 2013, to be invalid. This decision was upheld by the Kansas Court of Appeals on February 26, 2016. Nevertheless, the appellee continued, amending the tax assessment on April 28, 2016, to pertain to a different substance at an old address of distributing, which is one of the entities owned by the Greenes, specifically Davey Greene, and increased the value of that assessment to $924,400 in its continued efforts to retain property and pursue claims against David and Marcia Greene, as well as Wholesale, another entity owned by the Greenes, specifically David and Marcia Greene for Wholesale. Then, after an informal conference with the KDOR hearing officer, those assessments, specifically the $924,400 assessment, was immediately abated.
So at that point, they owed nothing, correct?
Correct, Your Honor. Nothing at all. Nevertheless, despite owing nothing, the appellee refused to relent. And once again, this is in 2016. The appellant, at this point, the plaintiff, filed its original petition on August 31st, 2023.
Okay, stop. Hold on a second. So, and this was something that jumped out to me about your petition. So what happens factually between September of 23 until August of 23 in this case? And I know there's another piece of litigation around 2021, and it ends up with a Court of Appeal ruling. But there's a big loss of time. So what happens during that time period?
So September of 2016, the Kansas Department of Revenue continues to go after the Greenes for this assessment. It ends up in district court in Butler County and then goes up through the Kansas Court of Appeals. That whole process took until August 31st of 2021. That gap was some litigation where the appellee continued to try to assert that it had some sort of assessment when this court and the district court both found, like this court did today, that the appellants owed nothing. So that's that gap in time, is when they were deciding what's going on. The appellee was still trying to assert that there was an assessment, even though they themselves had abated every assessment.
Did they also keep some property and not, that they had seized and not return it? I mean, what is the real issue? Is it the delay? Is it their lack of returning the property? What's the crux of your litigation?
Absolutely not. So we'll touch on this later, but to give you it in a short paragraph, in 2016, the Kansas Court of Appeals officially upheld that this original assessment was invalid. The appellee did not abide by this, kept the property, kept an assessment on my client's business and themselves personally, all the way until 2023 in October. This caused my clients to go out of business. They lost both of their businesses, one of which had been around for 45 or so years. The other had been around for 20 years.
Hold on a second. So the loss of the businesses, is that related to the funds that you believe were wrongly retained, the 62,000? I mean, what were you alleging was the cause of the loss?
So they went out of business for a couple reasons. First of all, wholesale deals a lot in tobacco. So when they had this assessment against them, it caused them to lose what's called direct status, which enables them to go with the, to engage with the tobacco manufacturer specifically. And they don't issue this anymore. I presume in some effect due to the litigation surrounding the tobacco companies. But that's gone. They lost the direct status, which is $50,000, or is estimated to be somewhere around $50,000 alone. And then additionally, the Kansas Department of Revenue held those funds. They held the property of the business, so they couldn't do business anymore. They stopped them from obtaining a tobacco license. And they had this assessment against them, which heavily inhibited their ability to continue operating their business. And my clients have pled and would continue to plead that if the appellee had just recognized the mistake they had made, returned the property in 2016, they would still be in business today. Now, more on that. And finally, on October 20th of 2023, KDOR returned the property, albeit heavily devalued and deteriorated. But it's been too long. It's too late. The appellants have already suffered tremendous damage. And if the appellee had simply stopped pursuing that tax assessment in 2014 when it was declared invalid by the Board of Tax Appeals, or 2016 when this court affirmed that ruling, the appellants would still be in business. And moving on to the legal argument of standard of review, I'll refrain from repeating the entire standard of review, which can be found in our brief, but I did want to go over a small section that this court set out in Rogers versus Wells Fargo Bank in A, stating that we presume Kansas courts may hear whatever claims a plaintiff pursues, and instead of requiring a plaintiff to demonstrate that a claim belongs in Kansas court, a lawsuit filed in Kansas may proceed as long as the facts included in the petition and the reasonable inferences that can be drawn from those facts state any claim upon which relief can be granted. Moving on to the...
Your two claims were under Tort Claims Act and Section 1983, correct?
Correct, Your Honor.
Okay, so would you like to talk to us about the Fifth Amendment dismissal then, or whether the judge dismissed that sua sponte?
Absolutely. So first, we contend that the district court did err in dismissing the appellant's Fifth Amendment claim under 1983. The appellant's original petition laid out 1983 claims for both the Fourth and 14th Amendments. However, upon further review, the constitutional violations that are at issue are more akin to Fifth and 14th Amendment violations. The amended petition updated that in the plaintiff's claims to include one for a Fifth Amendment violation. But at that point, it appears that the appellee did not notice the addition in its motion to dismiss, or the motion to dismiss the amended petition, rather. It lists out all the changes made to the petition and doesn't recognize that there was, in fact, an additional amendment led to the 1983 claim.
But did they argue for dismissal of all the 1983 claims?
They specifically addressed the Fourth and 14th and did not touch at all on the Fifth Amendment. And in fact, the cases that they cite for their defense or their motion to dismiss the Fourth Amendment claims hold that the parties' claims in those cases are better characterized as Fifth Amendment claims. which is something that, of course, the appellant recognized after its original petition. So even in its own motion to dismiss, the cases that they cite recognize this distinction and recognize that the Fifth Amendment is a more proper avenue to pursue a 1983 case here. Now, as the district court noted, the Fifth Amendment to the United States Constitution protects individuals from government action that appropriates their property without due process of law and without compensation. And, reaffirming the fact that citizens and businesses have a fundamental right to own their property. The 10th Circuit has consistently linked the deprivation of property without due process to the Fifth Amendment, and the 10th Circuit refers to this government action as an illegal exaction. Specifically, the 10th Circuit held that an illegal exaction claim exists when the plaintiff has paid money over to the government, directly or in effect, and seeks return of all or part of that sum that was improperly paid, exacted, or taken from the claimant in contravention of the Constitution, a statute, or regulation.
Do they recognize that same thing after the property has all been returned?
Correct, Your Honor. The illegal exaction is, I apologize, I misunderstood your question. We would contend that they do, that the damage has already been done because the actual conduct that was unbecoming was the holding of the properties, especially the bank account, after the tax assessment was held invalid. And this case was, of course, originally filed before the property was returned in any way. So to hold that case law to only apply when the property is currently being held would render an absurd result.
I'd like to direct you to the parties. Let's talk about the parties, the defendants in your 1983 action. Okay, so you have Kansas Department of Revenue, and then you have Director Steve Stotts in his individual capacity, and then also in his official capacity. So can a 1983 claim be maintained against a state agency? Is it a person under the statute?
Your Honor, the way the case law kind of bifurcates this, you can pursue monetary damages against the director in his personal capacity, and then you can pursue kind of, I guess, call it injunctive action or some sort of specific performance against the director in his official capacity. This case was first filed when the director still had control of appellant's property, and still action on his behalf was still required to release that property and release the bank accounts. And so that's the basis of the official action. And then the action against him personally under 1983 is for the failure to return this property when it was due, for holding this property past when he was allowed to constitutionally. And for the damage.
But as far as the agency itself, do you agree that case law says, it's not a person under the statute? So we're setting that entity aside for that claim?
Sorry, could you repeat that, Your Honor?
So the agency is not a person under 42 U.S.C. 1983, correct?
Correct.
Okay, so we're talking about Director Stotts. And then when you talk about him in his official capacity, that would just be in the nature of injunctive relief. And so it would have to be in his personal capacity for damages. You agree with that?
Correct, Your Honor.
And so there's what injunctive relief would even be left on the table as far as him in his official capacity?
I think in our original response to the motion to dismiss, we kind of recognize the fact that the personal capacity is really the only issue outstanding now that they've returned the property. The original case was, of course, filed before that. So that's the holdover there.
Okay, and I'm not trying to put words in your mouth, but really then what we're focused on are his actions in his personal capacity for this claim. Is that fair?
For the context of the 1983 claim specifically, yes.
Okay, thank you.
And getting to the district court's ruling on that issue, the district court, on its own, decided that there are no substantive claims against Mr. Stotts in his individual capacity. The plaintiff must show that defendant Stotts took deliberate action in directing a constitutional violation and allowed that violation to continue. And touching on that, the appellants were taxed under the Kansas Drug Tax Act. Specifically, they were taxed under KSA 79-5205A, which states that at such time as the director of taxation shall determine that a dealer has not paid the tax as provided in KSA 79-5204 amendments thereto, the director may immediately assess a tax based on personal knowledge or information available to the director. This is just clear evidence of his personal conduct, and the district court's decision otherwise is an error.
You have about 1 minute before you're getting into your rebuttal time, and that's fine.
Thank you. Moving on to the torts claim briefly, which is probably best left to the brief just because of its complexity. The Kansas Department of Revenue is clearly able to be sued on its own. The Kansas Torts Claims Act gives permission to do so. At most, the arguments levied in the appellee's brief are typographical errors. And moving on to the immunities themselves, this court held in the estate of Randolph versus City of Wichita that immunities under the KTCA are to be narrowly construed consistent with the overarching rule of allowing governmental liability. Appellant's claims in torts today are not in trying to hold KDOR accountable for the assessment or collection of taxes or special assessments, but rather the retention of that property after the assessment has been struck down. Finally, at the district court level, the district court erred in holding that only a judicial process was sufficient to sustain a claim for abuse of process. The Kansas Supreme Court simply feels differently. The Kansas Supreme Court has spoken on this issue in Lindemann versus Umschied, which is at 255 Can 610. The court looks at when an action can be first successfully prosecuted, and in doing so, it looked toward the qualifying event, specifically the administrative hearing. And the Kansas Supreme Court's decision there would govern the abuse of process claim.
I have one quick question before we end your part of things. So, we have the Bloom case. When we're talking about your claim, abusive process claim, and the argument is this even applicable to an agency process versus a judicial process? And so Bloom is a case that's cited too often that says it has to be a judicial process. And on page 14 of your brief, you're citing the Tillman case, and implying that the Kansas Supreme Court has overruled Bloom somehow. Can you explain why Bloom isn't still good law?
I believe the main case we used to overrule Bloom, or at least assert that it should be overruled, is this Lindemann case, where the Kansas Supreme Court held that an administrative process was sufficient to mark the start of when an abusive process claim could be successfully prosecuted. There's never been a Kansas Supreme Court case, at least one that I could find, that required a judicial process. So we would contend that the Lindemann case controls there and asserts that an administrative process is sufficient. And to the extent that there is a judicial process necessary, the appellee pursued these cases in district court and at the Court of Appeals, and we would hold that qualifies as a judicial process as well. Thank you. I'll reserve what time I have left for rebuttal.
Okay, very good. Mr. King, you may proceed.
Thank you, Your Honors. I want to clarify some of the points that were made by counsel. Part of the difficulty of this case is the ambiguity of the language in the petition, and that therefore gets repeated again and again in subsequent briefing and before the courts to distinguish what actions, what assessments we're talking about. And the department contends it's absolutely essential to be clear on those things, because that will determine what actions, what legal basis there is for any potential cause of action. So, for example, what I'm talking about is counsel uses language such as go after the Greenes or pursue these sorts of things. We talked about how there was an original assessment. While that original assessment was pending in litigation, there was a Court of Appeals decision in a different case on the specific substance that was at stake. The litigation continued before the Board of Tax Appeals in this case with the Greenes. The Board of Tax Appeals found in favor of the Department of Revenue. It was the Greenes that appealed under the KJRA to the district court on that first petition. So in terms of the Department of Revenue, there was an existing Board of Tax Appeals decision that found in our favor. And so if that's the assessment the Greenes want to talk about, it's hardly accurate to describe that as somehow an inappropriate use of process on the department's part defending a decision that it had. If counsel is talking about this second amendment, then counsel has admitted himself that yes, while there was an amendment, the department itself abated that amendment shortly after issuing it. And I think those facts are essential to keep in mind in terms of what we're talking about, because the language of the petition is unhelpfully ambiguous, in our opinion, on this particular issue. When it comes to the question of abuse of process, therefore, it's necessary for the court to analyze the question by looking at what is the process that's being described. What process are the Greenes saying was inappropriate? If it was agency process, as your honors have already pointed out, we have case law talking about how that's not sufficient. The counsel talks about the Lindemann case somehow overruling the Bloom case, but that's anachronistic. The Lindemann case preceded the Bloom case. The Bloom case was a Court of Appeals decision that distinguished the Lindemann case from the Supreme Court. That Bloom decision has been reaffirmed in subsequent Court of Appeals decisions. The Supreme Court has denied review on those, has not taken those up. So as far as the department is concerned, the Bloom reasoning is still valid, and agency action in terms of initiating an assessment is insufficient to be considered for the tort of abuse of process. If we're talking about judicial action, then we're left with the Greenes taking the initiative to instigate a judicial action and appealing the Kansas Board of Tax Appeals decision. If we're talking about the length of time it took to return the property after the conclusion of the litigation, there was no process involved in that at all. At the most, it was a failure to respond at the conclusion of the litigation in an appropriate way.
And what was that property that was retained, and for how long?
The question is, how long was it retained?
Yes, and what was retained?
What was retained? Off the top of my head, I believe there was an automobile, there was some cash, I believe there was some equipment that pertained to the business.
Okay. And for how long?
And for how long? I believe the timeline was there was a denial of review by the Kansas Supreme Court in 2021, and the property was returned in 2023.
Thank you.
Addressing the question of not abuse of process, but the Section 1983 case here, as the court has pointed out, we're not talking about the agency. We're not talking about Mr. Stotts and his official capacity. We're limited now to the question of Mr. Stotts and his private capacity. And again, the court has to ask, what does the petition allege that Mr. Stotts did to direct a constitutional violation? In the factual allegations in the petition are sparse in terms of what's actually being alleged. We're told that Mr. Stotts directed this assessment that somehow he knew to be fraudulent. Again, the court has to ask, what assessment are we talking about? Is it the first assessment that the plaintiffs admit was legitimate when it was first issued and then was subsequently litigated? If that's the case, that isn't enough to sustain a direction of a known constitutional violation. If we're talking about this second assessment, we have a situation where the department itself abated it in a matter of a few months in the context of administrative process before it was ever even litigated. And on top of that, in terms of identifying what it was that Mr. Stotts supposedly directed as a violation. The sole basis that the plaintiffs are alleging Mr. Stott's personal involvement was the fact of his holding the office of the Director of Taxation at the time. And there's no allegation that Mr. Stotts himself did anything specific other than being the Director of Taxation. Plaintiffs want to claim that because the statute says the Director of Taxation has the authority to do these things, that Mr. Stotts was somehow personally doing all of the tax assessments for the state of Kansas is, we believe, an unreasonable interpretation. In any case, the district court rightly understood that what we're dealing with here is the plaintiffs had a tax assessment. Tax assessment was litigated. They were afforded due process, and therefore, rightly, we believe, dismissed this claim as well. In terms of the allegation that the department never addressed their Fifth Amendment claims, the department, in its original motion to dismiss the amended petition, was admittedly brief, but did talk about how Mr. Stotts in his personal capacity was qualifiedly immune. And it's in the department's response or reply to plaintiff's response to that motion to dismiss, the issue was more fully discussed. So it's not as if there was no discussion of this topic at all before the district court ruled. In conclusion,
I'm just wondering if you're thinking that it's okay in the future for the KDOR to retain someone's property for approximately 2 years before returning it, and that they are without recourse.
Well, first of all, the department is not contending that it's okay. We admit that this was not an ideal situation. We've attempted to rectify that situation. So now we're not trying to make the case that this should be standard operating procedure. What we're trying to make the case is that there's no legal cause of action here. In terms of your question of was there recourse for the Greenes? Absolutely, there was recourse. They could have filed some sort of motion in court, presumably. There could have been a mandamus action, presumably. There were actions, potentially even their illegal exaction claim. The purpose of those illegal exaction claims, according to the case law, is for the return of the property. So we believe that, yes, there were legal mechanisms that the Greenes could have employed beyond even just interacting with the department further on the return of the property. But in terms of so the sufficiency of the petition to make out a legal claim, especially a legal claim for monetary damages, we believe is insufficient, and the district court was correct on that basis.
Thank you, counsel.
Unless the court has any questions, we'll rest there.
Very good. We'll move on to the rebuttal then. Thank you.
Thank you, Your Honor. I'll keep it brief. I just want to touch on a couple things. One, the appellee reference, or I guess alleged that in the motion to dismiss, they contained arguments relating to the qualified immunity of Mr. Stotts. A reference to being qualifiedly immune is not sufficient to preserve every 1983 action, because the reason the appellee said he was qualifiedly immune is because the case law on the Fourth Amendment was insufficient to pursue a 1983 claim. He was only qualifiedly immune, according to the appellee, because the Fourth Amendment is not sufficient for a 1983 claim. It is a very specific argument relating to a very specific amendment under 1983. Furthermore, the statute is plain. The Director of Taxation is the only individual able to levy these taxes. The appellant has made it clear that it is our allegation that Director Steve Stotts levied this tax. If the defendant or if the appellee wants to prove otherwise, he's welcome to do so at a trial level. And then finally, on the Bloom versus Lindemann case, even though Lindemann came first, it would, I guess, preempt the Bloom case because it's a Kansas Supreme Court case versus the Kansas Board of Appeals case. With that, thank you all for your time, and we would rest.
Thank you to both counsel. We really appreciate the arguments today and your flexibility in getting this set. And we will confer with Judge Coble when she's able and get you an opinion then. So we'll take this case under advisement. So with that, court is in recess.
Thank you, Your Honor.
Thank you, Your Honor.